what your documentation says. I'm talking about the petitioners.
Yes, my lord.
Yeah.
When I saw your directions, my lord, I was hoping the question of scrutiny could be determined in the trial. Sometimes we got
In the trial.
yes, there can be some.
But if they can make a case for it now, why not? They have an application.
Fair enough, my lord.
That application includes an application for scrutiny. I hear you.
Yes.
We can still redo it
Yes.
at the time of the trial if the justice of the case requires.
Yes.
There's nothing that we can't do. Yeah, but I understand what you're saying.
Again, beg to be guided. I want to borrow the wisdom by counsel for the IPC that we have to lay the basis why we need to either have scrutiny or recount. My lord, would it be sufficient enough to lay the basis through the affidavit, or we might have to have the witness at the dock and lay the basis why we need recount or scrutiny in a particular polling station? Because basis must be laid, and that will be prudence. And if we take at this time, Lord, will it prejudice our case as a petitioners?
I actually have two options. If I decide that the petition outcome, that the two parties are very close, I don't have to have a basis laid. And that's our jurisprudence too. So there are cases where 127 votes was considered very close, and therefore no real basis has to be laid. In this case, you have about 495, 494. The difference is 494. I'm not sure whether it is too close or whether it is very far. Is too close less than 100, or is it more than 100? It's a discretionary point. Mr. Kamoto.
Yes, I can respond to that question.
Yes.
Yeah, they have actually been smaller margins than that, and the winner has always been declared to be validly elected. So those small margins are common in that part of the country.
We are not talking about the outcome of the scrutiny. We are talking about whether or not scrutiny should be done or recount. So you can have a case where the difference is 10, and the person who was elected at the first instance remains elected. Is that what you're talking about?
I'm in agreement with the perspective by the court. I think it's true. It's possible that even the margin is 2 votes, but still the process is sustained.
Correct.
Yeah, my lord, we've just whispered with Mr. Mongela, and we've also agreed that after we leave this place, we'll also continue to engage and see which parts of the application can be resolved as we go along, so that we don't have to submit too long on things that can be settled.
Excellent.
Yeah.
Thank you. That is exactly what we are looking for.
Thank you.
That kind of cooperation between you as officers of the court.
Yeah.
Sometimes you are always fighting.
Yeah.
And I know you are fighting for the rights of your parties.
Indeed.
That's totally understandable. But you are now, that is real assistance to the court.
Thank you.
Yeah.
Thank you.
So should we retain the orders the way we have done them?
We can, my lord, we can, but the challenge I was finding is if you look at the nature of scrutiny which is being sought,
Yes.
it is not just the scrutiny of the ballot. There is sought therein, my lord, scrutiny of the system, the technology which was used.
Mm-hmm.
And those are some of the challenges we are having with whether a basis can truly be laid, my lord, or rather whether it will not have been proper.
Just highlight, for example, the ones you're talking about. I'm looking, for example, at number 4. Notice of motion, prayer number 4.
Yes, my lord.
Is that one of them?
Complete Kian's logs, which, yeah, those kind of things, my lord. Complete Kian's logs, Kian's servers.
Yeah.
My lord, we would have wanted you to hear the witnesses so that you know whether there is anything which is questioning the Kian's logs.
The witnesses have already testified through their affidavits.
Okay, my lord. It's okay, we can find it.
Let's do the application.
Yes.
Because it is open to me to give directions.
Yes.
Having heard what the application is saying and
Yes.
what the parties argue,
Yes.
I can still say I don't think
Yes.
that we are yet ready
Yes.
to deal with the Kim's issue.
Yes.
Let us proceed for hearing.
I hear you, my lord.
What I don't want is for us to be having applications coming up again during trial.
Okay.
Because we are going to, today, we will discuss when is the last application going to be made.
Thank you, my lord.
Okay. So that we have a roadmap. When we set dates for trial, it's just trial. We will not be having applications pending as far as possible. So let's retain the orders the way we have given them. 7 pages of submissions with authorities annexed, duly highlighted. Then the second application, we have already given orders or directions for it, and we concluded that. Is there something that we did not deal with in the second application, the one that came up this morning?
That one we had already concluded.
We had concluded.
Yes.
All right. So for this particular case, I don't think we have any other applications.
There is, my lord.
Yes.